The Second Amendment is one of the first 10 amendments that were passed by Congress on September 25, 1789, and were ratified on December 15, 1791. The Second Amendment states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The Second Amendment has been fiercely debated by pro- and anti-firearm camps concerning the original intent of the framers and the right of the people to possess firearms. It has become increasingly important over the years with mass shootings, gun laws, and the rights of the people. Just two of the many examples of the debates on what the framers meant are illustrated from Michael Waldman and Wayne LaPierre. In the Second Amendment, a biography, Michael Waldman went back to the framers' original arguments and felt he made two discoveries. The first being, out of all the Bill of Rights, the Second Amendment was probably the least debated. The framers were very opposed to a standing army because they were suspicious it would lead to a military rule. However, they felt every man would belong to a citizen militia. They were not allowed to possess a firearm. They were required to, because it was their duty. Waldman felt the debate over the Second Amendment in the summer of 1789 was among 12 congressmen who never mentioned the private right to bear arms, only arms for a militia. Obviously, the idea of a militia died out and was replaced by a standing army. However, Wayne LaPierre, best known for being the executive vice president of the National Rifle Association, disagrees. In "That's Not What They Meant," he states, "A common claim of the anti-gun lobby is that the Founding Fathers never meant that individuals should be armed. They only intended for the Second Amendment to apply to a militia, such as the National Guard. These self-proclaimed interpreters of the Constitution also ignore the Second Amendment's specific reference to the right of the people. The fact that the rights of the people appear in the 4th, 9th, and 10th Amendments as well, and that the courts have ruled repeatedly that these rights belong to individuals, matters little to them. They retreat to their standard charge that the Founding Fathers never intended for the people to have the right to keep and bear arms." End quote. Wayne LaPierre furthers that even a simple reading of the Second Amendment would refute their anti-gun sentiment. He uses the examples of the Boston Massacre, Patrick Henry's Liberty or Death speech, the fact that Washington, Jefferson, and Madison were all avid gun collectors as examples that the framers intended for the right to bear arms as a right for the people. Waldman and LaPierre are just two of the many examples on the controversy over the original intent of the framers. In 1939, the Supreme Court upheld the nation's first national gun law, the National Firearms Act, which put limits on sawed-off shotguns and machine guns because the guns had no reasonable relation to a well-regulated militia. However, in 2008, the Supreme Court ruled in D.C. versus Heller that the Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia, and to use that firearm for traditionally lawful purposes, such as self-defense within the home. The court based its holdings on the text of the Second Amendment, as well as applicable language in state constitutions adapted soon after the Second Amendment. The Heller case immediately drew criticism from legal historians, advocacy groups, and legislators who felt the only outcome of Heller would be additional litigation over gun laws. In fact, the day that Heller was announced, plaintiffs filed suit against Chicago's gun laws, and ever since, the number of court cases regarding gun laws has skyrocketed. The Supreme Court ended up ruling on that Chicago case and ruled in McDonald v. Chicago that the federal gun laws also apply to state and local governments. However, the court reiterated its ruling in Heller that the Second Amendment only protects an individual's rights to possess a firearm for self-defense in the home, and that a wide variety of gun laws are permissible. Most states have gun laws concerning who can purchase guns based on age, prior offenses, mental capacities, wait times, and background checks. However, there is so much litigation concerning the Second Amendment, the courts are literally bogged down with hearing the cases. The Second Amendment is extremely polarizing in America today and applicable to modern society if it is a constitutional right to possess a firearm or not. The intent of the framers will never be known, but certainly will be debated for decades to come.